Welcome to Clause 8, the #1 podcast on intellectual property, trusted by top in-house counsel, judges, and policymakers worldwide. Hosted by Eli Mazour, we bring you in-depth conversations with the personality shaping IP. Brought to you by TradeSpace, where ideas take flight.
All right, today we're lucky to be joined by Wen Xie, the expert on everything AI and IP. Thank you so much for joining Clause 8.
Oh, thank you, Eli. I so appreciate you having me.
So whenever something new about AI comes up, I'm like, maybe we should have on Clause 8, and who can I invite? Your name always comes to mind, so I'm glad you're finally on here, and we could discuss all that. We were chatting a little bit about careers and everything before we started recording, and because I do this podcast, people think I have this like insights knowledge about stuff I don't have,
but you do though.
Yeah, but
our conversation just showed me you do.
But one thing people always ask me is, especially younger attorneys, like, how do I become successful, or like, how people know me? And I guess one theory that I have is really embrace like some emerging trend in like IP and patents.
One. Yeah.
And I know you've done it with AI. Kind of, can you tell us like a little bit about that? How did you get into AI and patents?
That's a really interesting story, and thanks for asking. The truth is, I got into it because my husband, who was my boyfriend at the time, when we first started dating, he's a veterinary radiologist. He came back from a conference and said, I'm a little worried about this AI. He says it's quite advanced. It could actually do what I do pretty soon.
And what year was this?
This was in 2017.
Oh, wow.
2017. And I said, you know what?
Like, I think of a time before ChatGPT, and so it's like 5 years before, I guess.
Yeah, and I'm like, you're just being dramatic. And
he
says, no, I'm really not. This is a real thing that's happening. So I actually started following AI trends because of him. And 2017, so Alice came out in 2014, but we were just all sort of reeling from Alice still,
I'm curious, do you remember what he saw at this conference that kind of made him think?
They did a presentation on AI.
Just general AI.
Yeah. This is recognition of images. So AI and imaging was really advanced.
Yeah.
And so I think they saw it live.
Yeah.
And it was a little like, oh my God. And because he said that, it always stuck with me. And because we were in the midst of a sort of software patenting crisis, which we still are, except we're more of the angry acceptance phase, whereas back then we were in the still like, I can't believe this is happening phase. But that's why I started following what AI was about, and then about patenting, and then AI inventorship came on, was a debate, and then now AI tool use for us, me and you, how it impacts us directly. It just it's branched off into so many little areas that you could get into.
So how did it impact your husband's field? It's kind of ahead of what we're experiencing in the patent field.
Yeah. So about, I would say 2 years ago, the company has come. He works for a large company that's actually owned by the Mars company. So they do candies, and they own veterinary hospitals and imaging companies. So they decided they actually want to start training AI, and they use their veterinarians, the veterinary radiologists, to help train the images. So as part of the things that they could do as, to add hours, if you want to make extra money, you label and train AI to take over your job, basically. And so that's what we're doing in the evenings. After dinner, we're watching TV. He's training the AI to take over his job. And I'm like, can you actually just do maybe like a 60% effort? I tell him, like, you don't need to be that good at this. He's over here labeling every little thing. So 60% effort is good right now.
So he's also kind of like using AI to advance his career. So.
Yes. And this is what he decided. He was like, I could either fight it, or I'll lose, or I could try to be at the forefront and be, offer something. And in terms of training, in terms of understanding the programs, and maybe, when it does get integrated, I will be part of that integration process.
Yeah. So you obviously you give mission subjects, and you write a lot about it, and you do videos about it. You're all IP Watchdog conferences usually talking about AI subjects. I guess, can you kind of share what kind of impact this has had on your career, and like kind of like what you think about like everything that's happening with the AI in terms of
Yeah, so it's really impacted my career. When I first started following AI, it was really like a random interest kind of thing. And I probably didn't consciously think, oh, I should follow the new emerging trends. That'll be good. But maybe in the back of my mind, I thought that would be a good thing to do as I was a younger attorney then.
yeah.
And I got interested in when Thaler Vidal was an issue, when Dr. Thaler filed for his patents, and
Okay.
the AI inventorship came along. I was able to ask him some questions, and it was that interview was published in IP Watchdog. We did it via email and everything. He was very
Yeah.
kind to answer questions, and it was a very interesting thing for me because inventorship was becoming a big question, and I feel like with AI inventorship, because of that was the first case that everybody focused on,
Yeah.
that shaped the entire debate. It shaped the debate in a way that we all focused on what AI did, AI inventorship. When really at the stage that we're in right now, it really should be about human inventorship with AI use.
Yeah.
Because the question really is what the human is doing. And that's what the USPTO technically wants to focus on, is significant human contribution.
Yeah.
The AI AI use can be significant but we have to focus on what the human does. But I think when with the Thaler versus Vidal, the DABUS case came on, we all thought about, oh, AI is inventing, AI is conceiving possibly. But it's actually a non-issue. What the AI does is a non-issue. It's actually what the human does with AI. And we're really trying to figure out, because it's evolving, it's kind of a moving target. What we're doing with AI is changing because AI is advancing. But it's about determining the human's role in all of this in terms of inventorship and in terms of AI use.
And I know you told me you spent some time helping clients with that. It's interesting because you mentioned your reaction to your husband telling you coming back from that conference. One of my first interviews was actually with Ryan Abbott, who's the attorney who for Thaler and who spearheaded all these cases around the world applying for patents that named I guess DABUS as the inventor or what it is. And I remember when I put out, and I thought it was fascinating. I thought based on the way the U.S. law was, they were unlikely to succeed. But
yes, because it doesn't matter. You can't patent it.
Yeah.
I can't be an inventor.
Yeah. So they were kind of like, I think they were, as you said during the closing interview, I think the purpose was to raise awareness about this is something, I guess, the legal community should be thinking about. But I remember the reaction afterwards. It was like, why are you wasting time on this? This is like so impossible, theoretical. And then after ChatGPT came out, kind of everybody's like, oh yeah. This is like you said, that became really the focus. But it's interesting to say now, like maybe it's kind of swung too much the other way because that was the starting point about, at the end of the day, if whoever's applying for patents, there's going to be a person behind that, right? It's unlikely that there's going to be a autonomous AI somewhere, kind of starting a business and inventing and all that.
Yeah. They had a lot of foresight with those cases by talking about the AI use issue. I would just say because it brought so much of the focus on what the AI is doing. And I think that's totally what the Copyright Office went into with the de minimis standard. It's all their analysis is a lot more focused on what the AI does. And it almost causes, you know what it does? It makes people start weighing the human to AI input. And if you think, if the AI use is significant, then the human input must be insignificant. And I don't actually think that's true. It depends.
Right.
But that's kind of what gets in your head.
Yes, it's a tool, And I know a lot of, so the Copyright Office, at least my understanding, you know better, is that they said if somebody uses AI to create an image or something like that, then you can't get copyright for that, right?
Well, it's the de minimis standard. So I'm not a copyright attorney, but from what I understand is if they've believe that if AI use was not de minimis, is beyond de minimis, that you have to disclaim.
Yeah.
And however that looks, I'm not sure what that looks like.
Yeah.
How do you disclaim a picture? You disclaim the AI use part. What does it even look like?
Yeah. It wasn't tested in courts,
Uh-huh.
but I actually heard Andre Yanku, who's a former director of USPTO, talk about it at a conference, and he seems to think that was a ridiculous.
Because practically, how do you implement that?
Yeah.
You know,
and it is a tool, so it's hard to understand. So if you use a camera to take a picture, it's a human is not, but everybody accepts that photography should be, a photograph should be copyrighted. So it's kind of like another tool. But going back to inventorship, I guess, one thing that I still hear, and I think, and I heard you talk about this before, especially from the stuff that came out from the last administration, companies are like super worried, like, do not contaminate any inventing with use of AI because they don't want to have some issue pop up with litigation about the use of AI. What's your thinking? What advice would you give to companies in terms of their inventors using AI and, filing for patent applications?
Yeah. So I think to say don't use, they're going to use AI, I think. And I actually think it's a good thing to use AI. So the test is significant human contribution. And so if you were to say keep records of your use of AI, I would focus on what
is
you
that
did.
test based on? The significant human contribution?
Well, just to put it really simply, like prompting isn't enough. If you were in there prompting and then AI came up with, so if you were to say, if you're the inventor, you say, I see a problem here. You put the problem in ChatGPT, ChatGPT gives you an answer to like a proposal for the problem, and you don't do anything with it. Like that alone is insignificant. You know, there are a lot of factors to think about, but that's kind of what I tell a lay person inventor, is that if you're just prompting, you're going to probably be in trouble. Because that's like the most practical way of putting it versus getting into the new factors and all that. Yeah.
Well, what should in-house counsel be thinking in terms of that? An engineer comes to them and says, I have this new invention. Should they be asking them about, did they use AI, or should they kind of, the less you know, or I guess the same way you figure out the invention. Like, what do you think about that?
Because you have to, that's a good question, because you have to kind of weigh what's practical, what resources you put into what, So I think in-house counsel, they're not going to get involved with what tools are most useful in terms of, R&D and development. But I'm not sure. I think they know if just because the inventors would tell them that they're using AI. I think that's been a thing that they just are very open with. I actually am not sure if they're consistently asking, proactively.
Well, I think it varies. Like I said, some, I think, from what I understand, some companies are like, because of some of the guidance, they're very concerned about it. While others, I'm sure, kind of accept it as a tool. But I guess the concern is that eventually there will be a test case where, if I know an inventor invented something in 2025, I'm going to, when I depose him, I'm going to ask, hey, did you use ChatGPT at the time? Did you use that? Or, whatever it is. And then try to kind of create a story, which I don't know, this would be probably far reaching, number 10 after pen eligibility, obviously all that. But I feel like there might be an opening, and, inventor might say, oh, yeah, I didn't come up with this. The ChatGPT came up with, or something like that.
What I would say is, under the duty of candor, don't delete any of your chats. Whatever you do is just don't try to hide the ball. I'm not sure if you have to show the ball so much, but definitely don't try to hide it. And if I were to advise them, I would say, really have, because you have records of your AI use.
You're saying that based on what the USPTO's last administration provided.
Because of the duty of candor and everything. So I wouldn't hide anything. Just keep it, do your regular thing, but maybe keep better records of what you're doing. And today, this was the output. We did this with the output. We experimented with this. We modified this. So, and keep a time record of in terms of so that you could really develop a story with that. This is what ended up in the final product. And because the test is to focus on what the human did, I would, if I were to tell them, because your AI used, and if you don't do anything with it, you like don't delete it. It'll always be there, but you should focus on keeping records of what you've done with it. And that will be a thing that's not easily tracked, but you should start thinking about tracking that.
No, that's interesting. I guess kind of like for trade secrets, you the fact that you have a record of these things, it might might be beneficial. So I remember during the last administration, they actually asked me to moderate the USP asked me to moderate a panel on use of AI and all that. And I asked the question, who thinks the USPTO should release guidance advising everybody about the use of AI and all that. And almost no hands were raised. And then the USPTO promptly released the guidance.
They already wrote it. JK.
They were eager. But I guess the one concern that I heard is that the duty of candor, some thought like you have an obligation to use AI.
Yeah.
And especially now, like there's AI in everything. So there's that concern. But
yeah, so I actually think the guidance, the way it's written, is actually to say it. They presume the ADS is valid, and that's a great thing. They say it's sort of unless you trigger the duty of candor, the way it's written, it has to be triggered, and there has to be some sort of extrinsic thing that happens. So I went out and said I invented this with AI, and then it doesn't automatically create any kind of duty. The examiner really has to act. So I don't think there's an affirmative duty at all. But the other thing is once it is triggered, then it seems that the information they can ask for is sort of limitless at that point.
Yeah.
And then the big fear is, okay, say you're the examiner, and now I'm like, okay, I got this. I got all this information AI use, and now I'm trying to apply the PNU factors. Well, I don't know what to make out of this. I need more information. That's the big fear. Is like if it is triggered, they're gonna try to piece together a story, and then they can't piece together a story because it doesn't make any sense because nothing is like the time doesn't make it. Nothing like ChatGPT isn't time stamped. I don't know what happened or why. So then it's like, oh, that I need more information, and it's like I don't have more information.
Unless it's a test case, it's probably a decent patent attorney should be able to help a client avoid that issue in the first place. But actually, I had Jerry Marr and Charles Kim, who's now the deputy commissioner at the USPTO, and they were headed the working group at the USPTO that put together that guidance, and they agreed with you. There is no affirmative duty to do that, and it's not
I don't think they
obligation.
want it either. I don't think they don't want it that hard. On them either.
But it's interesting. Obviously, a lot of the concern came out because former directors Iancu and Kapos had an article in the Wall Street Journal, which is not often that you have an article in the Wall Street Journal which they raised that concern, but. I think,
after the guidance came out?
After the guidance came out. And I think it is more of, I think maybe a messaging thing, kind of like maybe it didn't show the appreciation about what the role of AI in the future. And I guess maybe that's kind of was their concern. The other thing, obviously, you mentioned when your husband came back from that radiology conference is what came to mind at that time is all the panel eligibility issues that were coming up. And I remember actually that's maybe my first thinking about, the intersection of AI and legal, because I remember even maybe before the inventorship issues is that, there was this theory, AI at its best, it's close to a human, whatever a human does, it's a human. So they're saying, well, the better your AI technology gets, you're just like approximating what a human does. And is that abstract idea, is that panel eligible under section 101? I guess maybe, I know you've written a lot, you've given a lot of practical guidance about how to kind of deal with 101 over the years. What's your kind of experience with that in the beginning, and has that changed?
Yeah, so definitely in the beginning, the confusion around Alice and all of that, it definitely was hard for practitioners and for applicants and everything. It was hard to strategize. It was hard to say, oh, this is exactly what you do. How do you get around it? We were just sort of like pulling things out of hats. And I think we still are. However, the recent cases, I feel I have illuminated a lot more. And put simply, I think is what they've been trying to say this whole time is they don't want apply it cases.
Yeah.
They don't want you to say, I took AI and I applied it to a new use. I take ML and I apply it to new
And you're
use.
talking about a recentive? Is that
Yeah. And I looking back, that's probably what they're trying to say at from the beginning.
Yeah.
But courts, when you let them decide, they decide issue at a time and they
Yeah.
carve out little specificities so you don't get a straight answer. But I think from what the USPTO, especially with their guy, they were all in a way trying to get at the idea is we don't want you to take known software, and apply it to a new use case and then have certain maybe
Right.
big parties carving out large sections of the industry and being able to, I guess, broad patents. They don't want broad patents.
It's interesting because I think there was an interesting period of time when, there was a lot of one-on-one issues with software, and then there wasn't a lot of, and then AI came about. And I think the trick some people saw is like, oh, let me just throw some AI into the claim is going to help with the pen eligibility issues. And actually, if you got into, I don't know, like a radiology art unit where they didn't see AI being applied, then it became like, from an obviousness standpoint, it became pretty difficult to find art.
That's exactly why I think, because that's why I feel like the whole debate about why don't you use 102 or 103 to do, I actually think it's because exactly what you said is because if it is applied to a new use, 103 might not have worked because the way we have to get every element. So whoever, I don't know, the powers that be decide, well, let's just use 101 then, because if 103 isn't going to kind of do it for us, let's just tack this into 101.
Yeah, but it was interesting even for like let's say technical use case. I don't know, a vehicle that's run by AI. And I know obviously by now it's not new. But at this point it's obvious. And then they put out, and I know you've written about that, when Yanku was director, they put out example 39, which is that
the training case.
Yeah, the training machine learning, and then they kind of supported, as long as it's all about AI, it's good. And then the last administration came in, and they put in all these new examples. And what I started hearing from examiners is, oh, those old examples don't apply, even though the USPTO never said that.
They never said that. That's right.
Yeah. I mean, in terms of core decisions, are there any core decisions that you think have kind of give you confidence that, hey, all right, just applying it is not enough, but if you're improving AI, it is enough? Is there anything that kind of sticks out to you from that?
Well, yeah, I think definitely at this point it is all about technological improvement. Even with Desjardins, it was all about technological improvement. And it was interesting because it was about specifically technological improvement with respect to computer programming. So I think the current director is trying to make it easier to meet that with software, the technology, not like a hardware improvement, but you could improve computer functioning with the software improvement.
Yeah, and Desjardins is that new, I guess, PTAB decision when Director Squires came in and they issued that. And I guess that's kind of, the pendulum is kind of swinging back in that respect, where they're trying to send a message that things are patent eligible, that improvements to artificial intelligence, improvements to technology, the use of artificial intelligence are patent eligible. I guess, is that your sense? Is that kind of like, if you're drafting a new application related to AI, let's say somebody's saying, hey, I have I don't know, a new microphone that works better because of AI, or whatever. I guess, what are you thinking in terms of like 101 for that? Like,
how does it work better?
How does the microphone work better? Right?
Yeah, because you have to be careful. It's not. It has to, the improvement can't be to like user experience. It has to be the way it's actually functioning that it improves. I don't, whether it's like it processes sound better or eliminates noise. Maybe it calculates. Maybe it corrects your tone for you. But it would depend, because there are nuances with respect to technological improvement. It isn't, they're very clear. No, they're not very clear. I take that back. But there are consistent, at least, with that. The technological improvement cannot be to the way a user experiences the improvement. The improvement has to be with the way that the computer experiences the improvement. And I think, at least at the PTO, they're trying to say that the way you program it can be an improvement itself. Yeah. Versus I've changed the hardware.
So I guess we were discussing kind of the interplay between all the examples the ACT administration put out with 30 about training AI, and then the new administration came in and they said, I guess when the DABUS director, a new one, and now this one is in August. They put out a memo right now. When Cook Morgan Stewart director Charles Kim put out a memo of a deputy commissioner there, trying to say, no, let me remind you what everything is, and trying to make the distinctions there. So I think they're trying to make it work. But I guess where do you think it's going in terms of like examination? I'm assuming they want to see many less one-on-one rejections, I guess, for AI. And
So the August memo was triggered by the fact that the 2024 guidance caused a spike in 101 rejections in certain technological centers. So that's why it was addressed to those tech centers.
Exactly, yeah.
So I think they're trying to correct it and say you're not. So the August memo was trying to rein in a lot of what they probably thought were deviances from what they were supposed to do. It's supposed to actually recite, and that's hard to do. Instead of 39 involved a mathematical concept, 47 recited mathematical concept. I see the distinction. I think they're distinguishable. I don't think they conflict on its face. I always thought that. So to me, I thought 47 should have been narrowly applied, and should always be narrowly applied. And that's what I would advise.
Yeah, maybe that. Yeah, I guess I don't think it makes a sense. Maybe on a philosophical or practical level, because of the way the system should work. But
it all conflicts with what the Fed Circuit is doing. So it's like, do they conflict with each other? Possibly, but everything conflicts with the Fed Circuit, who comes in and it's like, oh, American Axle, this is directed to Hooke's Law. It's like, where in Hooke's Law is in this claim?
Exactly. So I think we're kind of at a very dangerous time, because actually what happened was when people say, oh, I'll just put AI and get that allowed in the patent office, and then within the patent office, you're right. What happened, and I've written about in Voice of IP, is there were like sorting rates of one-on-one rejections in the AR units to 21 Technology Center. But what actually I found interesting, and I'm not sure if I followed up with that about that, but it was kind of spreading like slowly into different R units to 2100. And the reason is they were training the different R units at a time. So as they were doing that, you thought like, oh, maybe this one is, I don't know, related to language processing or whatever. No one-on-one rejections. Next day there is, and it kind of slowly spreading. New administration now comes in and stops that. But you point out, hey, it doesn't mean that whatever the guidance was, whatever USPTO was, the Federal Circuit has repeatedly said, we're going to form our own opinion. So I think it's somewhat a dangerous time in terms of you can file a patent application today, and who knows who's going to be in charge at the USPTO by the time the continuation will be examined. But even more importantly, if it's issued as a patent and you care about it being actually a credible, strong patent, you still need to have a technical story there without just relying on being an AI invention.
The fact that it's a constantly progressive story is somewhat... It's hard on patentees and applicants, is the fact that 101 is so constantly progressing in that way, and that there are stark differences between, the patent agency and the courts. So I mean, I feel like under the current director, he's tried to clarify a lot of things, but again, it's a progressive kind of section.
I think they're trying to do the best they can with the current what they have.
They do. No one comes in and totally does something crazy. I want to say it's like they try to work within a framework that they were.
Well, I don't know. I disagree with what the last administration was doing. That, so, but this is more my sense. But I guess because I think on a practical level, examiners should be focused most of their time on, looking for prior art, applying the prior art, and that's what will actually make sure the USPTO is issuing the best examiners, instead of putting on the obligation on the examiner to make sense of the mess of what is the Section 101 law. That's just my thought. But anyways, I guess the one possible solution that's been out there for years is PARA, which you've written about. It's the Patent Eligibility Restoration Act to fix 101. What do you think about that? What do you think I don't know if you followed some of the latest.
I've fallen a little off of the big story.
Yeah.
I'm sort of focusing on the day-to-day grind,
Yeah.
I want to say. But, I mean, definitely you need to get the adults in here.
Yeah.
There's the fact that there is, so after Alice, it was the constant inconsistency, the lack of clarity overall that really hurt the innovative community. I think at this point, it is just the sort of, we're going to accept that there's two different systems, that the PTO follows one and the Fed Circuit does something different. One, the agency has enumerated categories of abstract idea. The Federal Circuit will just say, like, oh, banking is an abstract idea.
Yeah. This
is directed to the abstract idea of tuning, axles. And that's it. That is a problem. The fact that their approach is so different, because when you advise clients, you want to give them something like, this is my opinion, versus you have to temper a lot of your, analysis that this is what will work at the USPTO. But obviously we all know the Federal Circuit follows something different. But the fact that, you just need something we would like guidance, as for me personally, is just everyone do this at least.
Yeah. Yeah. I think at least the new guidance, the new decision that you mentioned from Squires, at least gives you something that you can have a common language with the examiner.
Some commonality. Right.
And obviously when there's like all these court decisions that went 10 different ways, it was kind of a game. All right, he could point that. It's like, all right.
Because Para isn't going to go rewrite to part 2 and B to whatever those steps are. Para isn't going to go rewrite Alice. So we're going to have to stick with the steps, the deviant steps, but at least you could introduce some commonality.
Yeah. And I think Para, some people have suggestions to get rid of Section 101 altogether. But I think Para, if you can clean it up.
I know. Okay.
Yeah. David Kappas for that. I think we did it when I interviewed him back, I don't know, many years ago. That's how long it's been a problem. So it's continued to be a problem. I don't think we've closed our solution. Even when we fixed it at the USPTO, there is that question about, are innovators who are innovating in the field of AI going to be able to obtain patents that they can rely on? Another issue that I guess I started seeing, I think they were trying to make a push for last administration, is 112. And I still see remnants of that sometimes. Even if you have a technological invention, but you say, hey, I'm using machine learning, I've seen something of like examiners say, oh, you don't describe all the details about how this machine learning works and all the details. And like, one of ordinary skill in the art knows how to apply machine learning these days. But I know you have thoughts about when you draft applications. I guess, what are you thinking about?
Because there's so much, the way you draft software, you inevitably use a lot of means plus function terms because of the nonce word, units, modules, whatever. It's easier to make the 112 rejection because of that. You gotta they want to be able to find the functional equivalents thereof, and you haven't described enough. So it's just an easy. Is it right? Is it not? It's like an easy give to examiners who like to reject.
Yeah. So I guess at least what would your advice be? Like, I don't know, describe at least the types of machine learning models that you might be using. Is that kind of the?
Yeah, I don't. It's also so like nitty gritty, I would look at. It depends on what the rejection looks like. If you're using AI drafting, if that's the thing, you could just put as like as a form paragraph in there. It wouldn't hurt, I guess.
Which leads us, I guess, to our next conversation about using AI. And I know. I guess we started with ChatGPT. I guess what do you think about like where AI is now? The large language models, all these tools out there. There's probably hundreds of them. How are you using it? What do you think is kind of where's that going?
So I have a method that I use, and it's a method so that the attorney isn't just prompting wildly, because that's the biggest thing with prompting with AI drafting is reining in AI's own logic, and you want it to get it to follow the logic of the inventor or what's known in the art. And it's not there's a lot of gap filling, and and it's hard to identify where they deviated from maybe what your inventor has invented in a way that would be, bring into questions of inventorship. It'll just is small. I think, oh, this is known in the art. They brought this in. That's fine. But what you don't want is for the LLM to kind of bring in something totally random. Oh, this does that, and that's not labeled or anything. So you have to identify it. So as the attorney, is like, how do you try to rein in all those like random hallucinatory content that you don't need? Sometimes the hallucinations are like, oh, that was kind of good, but then sometimes it's like, no, how do you keep this out?
Yeah.
So it's about getting the AI, prompting a way to get the AI to follow a certain logic. It's getting you to follow a certain train of logic system so that you get easier, in a more efficient way, identify when the AI probably deviated from that. And that there's a lot of it depends on how well the attorney themselves know the state of the art. And that's what it comes down to, is if you understand the state of art pretty well and understand the invention pretty well, you could tell right away when something probably shouldn't be in there.
So what is your approach, I guess, to rein in the AI?
So what I would do always, so drafting is one thing. So writing is the order with which you present information.
Yeah.
So you don't want AI to take over that. So as a human, as a writer, as a drafter, you want to be in charge of the order that the information is presented. As long as you're in charge of the order that information is presented, you will have a lot more of a reign and control over the content. So what do you want to do? Is you want to describe the parts a certain way. And this is what you always, and the way you prompt, I always prompt to try to get to certain answers. So I'm not about writing like magic prompts, to be honest. Like prompting is an iterative process. If my prompt is stupid, I'm just going to rewrite it. But it's the order with which you prompt, what you ask, when you ask it, what does it do, what are the parts, how do the parts.
So your approach is like do more discrete portions of that.
Yeah, exactly. Yeah. I do discrete portions. So I'm not drafting like any large section, because when you draft a large section, I can't check that, and I don't know what this is, and I don't know where the wrong.
That's interesting, and it's interesting. I guess some of the best tools that I've seen that do that actually think about it that way, where it's more. You don't just like put an IDF in and spit out an application, because I think that actually creates more work for the an attorney than running from scratch. But being able to use it to write discrete portions of the application, and maybe actually use like models or examples that you have, any kind of. I guess that's one of the things. Is like there's obviously a lot of tools out there. I don't know if you've tested any of them or not, but what is your experience? Is it like, have you run into any tools that you really like, or is it like you're like ChatGPT is good enough, or like any of Claude or whatever, or Grok? What's your experience?
So for me, I'm a ChatGPT Gemini gal. But I haven't done a lot. I'm like, this is good. I like it. I kind of stick with it.
Okay.
I don't have any tools that are, because I'm by myself. I haven't used any tools that's specific for attorneys. I kind of just use the general tools that everybody else uses. Yeah.
And do you use like ChatGPT versus Gemini for one versus the other for certain tasks?
I actually kind of use them at the same time.
Okay, and see what's better.
Yeah.
And I see that as an approach. There's obviously tools that allow you to kind of put the prompt on different things. It's interesting. I actually heard you talk to, you had an interesting conversation with Gene Quinn about this, about using ChatGPT. And the issue that I have sometimes is like, when I use ChatGPT, like, let's say I'm trying to figure out like, hey, is the way I put it better, or is there a better way? Sometimes when I get the result, then I'm like, I start questioning my own.
That's a funny thing. It's like, I thought it worked different. Am I wrong? Or
and some people have the other issue where they're like never happy with the output, but that's
it happens. It definitely happens. For sure.
Yeah, and then I think another thing is obviously me and you. We have been kind of lucky to. I think we're lucky in some ways that AI is coming into where it is. We're pretty far into our careers, right? So we kind of,
Yeah, it's rough on the news, guys. Oh my gosh. I thought I had, so I graduated in 2013. It was still like Great Recession era. And I thought we had a rough, but it's probably rough out there for people just graduating.
Yeah. But I understand even like you're starting your first job. I guess for me, one thing that I run into is like, you're trying to find, let's say, an answer to some complicated technical issue or question that you haven't solved before, you look for an answer, you can't find it, then you go to ChatGPT.
It gives you an answer.
Gives you an answer, you're like, oh, that must be it. But I know enough to say, hey, I cannot accept that.
Yeah.
I need to really get to the bottom of it and figure out if that's the right answer or not. But like for a new person starting out, there must be a lot of situations like that, both with doing the legal work itself and the technology political piece.
Yeah.
Well, do you have any like thoughts about like you're a brand new attorney or a brand new patent agent? Should you even use that ChatGPT AI, or should you like? How would you like?
My answer is figure it out. I don't know how, but figure it out, because that will be their challenge. They have to learn how to use it, and I feel like the one thing that's most important when you're using something like ChatGPT or Gen AI is that you have to know enough to know when you don't know something.
Yeah.
So that you could take a pause and be like, this thing I'm going to carve out, not use, come back to ask somebody else. And that's, I feel like at least get a strong enough understanding when you could confidently say, I know this, but I don't know this. So I could have a little cutoff point. Don't go here.
Yeah. And I guess as for the technological piece, it's I think it's true for most attorneys. Obviously, we're not the engineers, we're not the inventors. So our understanding of it is, a certain level enough to write a good patent application. It's not to know it at the level the inventor and the engineer knows this technology. ChatGPT actually might know more than you do about this technology,
right? But
you still can't defer your judgment to it.
It depends. Yeah, I guess it depends on how well you could, it comes down to, like, if you know it really well, you could maybe on your face be like, that could be, or if it's iffy, you don't have to include it, like that's what I'm saying. You're trying to get fully supported, application, but we're not trying to write like War and Peace over here. We don't have to go into every.
Well, right, yeah. Sometimes less.
We're trying to support the claims.
Yeah, I think less is more. It's very true a lot of times, and ChatGPT kind of prevents that sometimes. I obviously, the other thing I guess I want to briefly touch with you because the USPTO has been focused, I think, to their credit, on AI for a long time, and they recently they had this, and I think they've been very responsible about it, kind of like thinking about how they should use it on their end. But now they have this new pilot, AI pilot. They previously had, so this is the new pilot for search AI. Well, actually, I forgot to ask you. I saw you had a piece about to defer 101.
Right, and that was a while back.
Yeah.
Right. Yeah, I think that was like 2 or 3 years ago.
Did you ever try that program?
No one asked to be a part of the program.
We'll just skip that. But no, I guess my question is, I guess maybe you have thoughts about the new pilot program that the USPTO has about you pay $500 to get this pre-examination search done by AI. And I don't know if you have thoughts about that program or about just the USPTO using AI to help examiners do its work.
I actually think the program sounds pretty neat. The one concerning thing is I believe that the examiner doesn't have to cite what's in the report, the preliminary report. So it kind of becomes like, well, what do? Do you need to cite it on the ID? US.
Well, it seems like it's creating more. You have to pay the patent office, and then it creates more work. You do have to cite an IDS. I can imagine.
I would say that you're getting, but I don't know. There could be definitely some instances in which you may benefit from it, and I'm curious. It's a pilot program. How good is the search tool? We'll find out. Kind of, is it worth the fee? I think the fee is like $450 or something, something like that. And that's for a large entity. I actually would imagine mostly it will be small entities that would end up using it, and the fees lower.
Well, they have to really know about the latest pilot program.
So I don't know. I think it's a good thing. People should try it. I've been telling my clients that it exists, by the way, just so.
And what has the reaction been like?
Nothing. No one says anything. Crickets.
Nobody wants to be
I don't know, the first pancake.
No, it's funny. I guess without the fee and without the extra obligation, I actually think that it might be interesting to, if I had a larger client, I would say, hey, let's try it, because who knows, maybe it will help lay the groundwork.
You're right. A
for
large
exam-
company probably would be beneficial to them too, because
Yeah.
it will be mostly searching for AI applications,
Yeah.
maybe. Yeah.
You mentioned you started your own firm, so congratulations.
Yes. Oh, thank you.
It's been, I don't know, 6 months. Is that
Yes. I technically incorporated a little bit earlier, but you got to wait for the California
Yeah,
bar
okay.
to approve you for a business, and they take a while.
Oh, wow.
Just so you
how long does it take?
Well, okay, so it was sort of during their. It took a couple months.
Oh, wow.
It
Okay.
took a couple of months, like 3 months.
Yeah.
And I hope they're not listening, but they were having a lot of issues with their bar examination
Yeah.
too,
Oh, yeah.
and everybody was doing that apparently, and not checking the new corporation application.
You got to focus, right?
I know, and I let me tell you, I was annoying. I called them all the time, and they stopped. I think they knew who I was.
Yeah.
One day I just got it. You're approved now. Go away.
Yeah. So it's interesting. I'm curious about how's it going, and tell us about your firm. And
Thank you. Yeah, it's going really well. Obviously, very little overhead if anyone's interested. So I price competitively. It's interested.
Yeah.
But if you're interested in patent drafting, I have a process for that. It's a 5-step framework. I do demos if people want to see a demo, but I definitely do demos. I also, you get a lot of it. People asking for advice on AI inventorship. If your inventor is looking to get some, somebody check these claims, I use AI for this. I get, I've gotten a lot of business from that, and that's been cool. I didn't think that this would turn into a business. To be honest, I kind of was just following a random thing that I'm doing. Follow your bliss, I guess. Follow your interest, AI inventorship.
No, that's great advice as well. So people reach out to me and say, should I start a podcast? I'm like, only if you want to. So.
Only if you think it'll be fun.
Yeah.
This has to be fun, right?
Absolutely.
I think, yeah.
No, so that's great to hear.
Mm-hmm.
Any advice you'd give to somebody else who might be listening to this and thinking like, hey, I might want to start my own firm one day, or how to think about that, and I guess what to be prepared for. I
would give them the same advice that I would give like younger attorneys. So when I was a younger attorney starting out, and I was at a small firm, and it was just and all that, you're just like the ugly duckling in the corner for a while. We were at networking events, and everybody's got their big team. My Finnegan and all the Finnegan people are there, and you just have to keep showing up, and eventually like stuff works out. But for a while, I was always networking by myself, and 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 you always feel like I'm alone. I'm always here by myself, and it's super awkward. And that's kind of what starting a firm is like in the beginning. So you have to be emotionally prepared for that. You got to pitch. Sometimes you feel like you're just like the human equivalent of finger guns, like you're all constantly have to be ready to pitch. But it's like you have to be outgoing, but it's also like a lonesome experience because, you're buyers, you're checking your own work, which is fine, but it's the big decisions that you do miss having somebody around with. Like, I really would love to bounce this idea off of someone.
That's interesting.
Yeah, but that's the advice, is to just be prepared. That's what it feels like.
We need I also like, obviously I have a lot of friends who have like their own firms, and it'd be cool to have kind of more reliable network of that, and maybe we can discuss that. But I'm more I guess it's interesting. You got to think of yourself the right person. What about the right timing? Like, is there a right timing when you're like,
this is when I go off on my own?
Yeah, like, is it, I don't know, early, late, when you have established clients, when you don't? Like, anything about that piece that you kind of wanted, like...
I wouldn't follow what I did, because I just kind of did it. I just like, just go and figure it out later. I kind of did that. Like, I didn't think long enough to think about. You're probably a much more methodical thinker.
Well, I'm just channeling what somebody else might
So it depends on who you are, and I feel like if you feel like you're in the position in life that I'll say this: it's about how much energy you have.
Yeah,
that's what it comes down to. How much of yourself that you could give to starting something new. If you feel like you're just really drained in life right now, you should take a break and then do it.
Yeah.
But it would
It's not going to re-energize you.
Right. Because it takes a lot of energy,
Yeah.
and it's mental energy, physical energy. So there are times in life when you're probably going to feel tired and drained,
Yeah.
And so I would say what it comes down to is how much energy you could give to starting something new. And that will be the thing that you
probably different situations, obviously. You'll need more or less energy. So I think that's really good advice. Any final thoughts? I know you recently spoke at the USPTO about AI and industrial designs. Any other thoughts about takeaways from that, or any other thoughts about AI and IP?
It was a great experience. It's great because you really get to talk to people at the USPTO. They're really trying to, they wanted to know how AI was being used in this industry. And there is a real intent to want to understand AI tool use practically so that they could do the right, they could set the right test or the right guidance. And that's actually a really great thing. They're looking for industry people who are out there in the field and how AI is being used, and there's a real thirst for that kind of knowledge, and I find that a really great thing because they want to know what's happening.
Yeah, no, I think it's definitely true because some people here at USPTO say, we want feedback, and they don't. People are very cynical about it, but knowing people at the USPTO, they're 100%. That's what they want. They want advice, feedback, how it's impacting all the different stakeholders. Because, obviously civil servants, anybody there has a certain set of experiences and views, but when they're there formulating policy, they really want to be thinking about everybody else. So I think it's a great takeaway.
Yeah.
Anything about AI specifically that I guess you're thinking about the future? What's the next?
I think that we touched on it's evolving as a tech. It's evolving as a law that applies the tech. It's constantly moving, and there's always so much happening. It's almost hard to keep up with.
Yeah.
But I think it's important to keep up with it. It's important. The best way to do it is to use it and to not be afraid of using AI. You could use AI for anything. Like just start writing some emails with the AI. It's probably gonna see how it goes. But if you use caution, someone's gonna read that.
Yeah, I think it's a good
low stakes emails. How's it going?
All right, well, great moment to end on. Thank you so much for telling your story and telling everything you know about AI.
Thank you so much for having me. I so appreciate this. This was really fun.